Step 5. Disclosures and discovery. In family court, disclosure and discovery is really not optional, it is mandatory. That means if you're going to use an exhibit, if you're going to use a witness, it must be disclosed, and Rule 49 sets out the mandatory minimum disclosures. The rule is lengthy, it's complicated. This lets you know not only what your obligations are in disclosure, but what you can expect to get from the opposing party. This brings us to the next topic on disclosures and discovery and the rules of evidence. In family court, the rules of evidence are relaxed. That means the same rules that you have in civil court. Objections to hearsay or authenticity of documents don't apply in family court. In family court, the general rule is that any evidence that's relevant will be admitted. That is, unless a notice of strict compliance is filed. A notice of strict compliance is not a request to the court, it's putting the court on notice that the rules of evidence, the civil rules of evidence, will be in effect. I would advise you to think long and hard before filing the notice of strict compliance. It makes it more difficult for you to prove your case. What that means is that instead of submitting a police report as evidence, you need to actually subpoena the police officer who has to come and actually testify, because that's the best evidence. The best evidence of what happened is not the report, but the actual witness who saw the event, so that's just something to keep in mind. Discovery tools. If there is, you looked at Rule 49, you need XYZ. Let's say you need access to their bank records and they're not handing them over, or you know they're hiding assets. Or you think there might be something really terrible, like child pornography or something like that. There are discovery tools that you can use in addition to the Rule 49 disclosures. The discovery tools are interrogatories, which are questions that are asked and served upon the opposing party. They must answer them within 40 days. There is a set of uniform family law interrogatories that are fantastic. I mean, they are fantastic. They ask for things like, name every account you have, name all the people who live in your house and any criminal record they have. It's extensive, it's great. You can also serve non-uniform interrogatories. Non-uniform interrogatories are questions that you make up. For instance, we thought the opposing party in one of my cases was hiding rental income, so we created a non-uniform interrogatory that said, identify each and every house you own, who lives in the house, how much the mortgage is, and what is paid in rent. That's not a uniform interrogatory, it's a non-uniform interrogatory, and you're limited in the number of those that you can use, but they're very powerful discovery tools. The next discovery tool you have available to you is the request for the production of documents or things or items. You can request someone's computer. You can request that that computer be imaged by a forensic analyst who then goes through and searches for things, In the child pornography example, that's a reason we would want to get their actual computer or image their computer or their tablet. We can also do that with someone's phones. We can look for bank accounts. You can request specific items, lots of specific items, using this request for production of documents. And again, what we'd want to do is think back for a strategy. Think back to what we must prove and then request what we need to using these discovery tools. A request for admissions is a separate document that goes out and says, did you do XYZ? They have to lock down yes or no. And why do you do these interrogatory and these requests for admissions? Because you lock down their answers, and you can use this as evidence, and you can use it to impeach them. And impeachment means you're proving them a liar, that's what it means. We want to start with these tools and using these tools and gathering our evidence soon. There is a reason that I put this in the process right after the filing of the original and initial documents. You do not want to wait. The reason is that the same information is used not only for trial prep, but for negotiation and for settlement. It's information that you're entitled to. A subpoena is a little different because it's like a request for production of documents or a request for a witness. That goes directly to the third party, a bank, a witness, a school, any third party who has information that you need.